Listing, please. Please give your name, item number, it's better. Yes, item number. Item one mentions, allow, please give it to the co-master. Yes, item one.
Item one promotion.
Have you filed affidavit? Yes, both counter affidavit, the results have to be like this. We'll check. Next. Can you go for it? Notice that the affidavit and counter affidavit filed less consequence.
Item two.
Non-renewal of this service, removing discontinued from service as occasional trainer. Where is the appointment? The headmaster here to take job order for execution of vocational training program. No, who is the petitioner? Also, who is he? How is he related with page 30? Page 30 is by some Soham Roy Mojumdar, addressing to the headmaster that they are appointed by RMSA as vocational trainer. So it is that your yes, what kind of appointment is this?
He was actually engaged by an outsourcing agency.
That Orion Edutech.
Yes, yes. It is called Orion Edutech.
Okay. And what is your relation with Orion Edutech?
Well, they have been outsourced to provide the provisional.
No, now is your arrangement with no. Is your contract with Orion continuing or it has been discontinued?
Presently,
it is continuing.
Yes.
So now who had withdrawn him? Orion had withdrawn him? Orion withdrawn him.
On the last occasion,
then you have to find a civil suit against Orion because your employer is Orion. Orion has a contract with the department, if I understand. And pursuant to that contract, Orion is required to provide vocational training. And Orion had appointed this petitioner that you please do the work on a part. Liberty, yes. I heard Mr. Shikdal and counsel for the petitioner, also heard Mr. B. Gogoi for the SCRT and Mr. SMT Chisti for the education department. The petitioner, Dr. Ashwar Hussain Mandal, was deputed by Orion Edutech Private Limited. And accordingly, Orion Edutech Private Limited made a communication dated. No date. Made a communication, sorry. No date. A communication available at page 30, annexation 9 to the petition to the headmaster stroke headmistress of Rampal Bill Higher Secondary School, Pokrajhar, informing that Orion Edutech Private Limited had been had been given a job order for execution of vocational training program in the school from the RMSA, bracket Rashtriya Madhyamik Shiksha Abhijan, Assam, for healthcare as additional subject as per norms. Accordingly, Orient EduTech by the State Communication informed the headmaster to accept the joining confirmation of the writ petitioner, Dr. Aswar Hussain Mondal, for the purpose. The grievance raised is that the engagement of Dr. Aswar Hussain Mondal had been discontinued. It is noticed that if there is any employee-employer relation of the writ petitioner, it is between the writ petitioner and Orient EduTech. And there appears to be an agreement between the RMSA and Orient EduTech to provide for the vocational training. It is stated that the arrangement with Orient EduTech had not been discontinued by the respondents in the RMSA. But it is the discretion of RMSA to depute any employee of theirs to undertake to execute the vocational training program. In the circumstance, Mr. A.R. Sital and counter petitioner do not pursue this writ petition any further, seeking liberty that the writ petitioner may be allowed to go for any other alternative remedy as may be available. Writ petition closed. Liberty under the law, if available, granted. Page 29. So what can be done? Where is that provision? What does it provide? It is open to the administrative department. So we cannot say it is open to them. It's a discretion. They can do it. So you make an application to the administrative department to undertake. Or how do you look, Mr. Chisti, Mr. Pekut? The language, I think it is open. Open means enabling provision. It's a discretion. They can do it. Okay, we provide that. If you want, you may do it. Heard Mr. M. Kolita, and counsel for the petitioner, also heard Mr. G. Pegu for respondent number 1 and 4, respectively, being the Chief Secretary and Deputy Commissioner Shivsagar. Also heard Mr. S.M.T. Chisti, and counsel for the respondents in the Elementary Education Department of the Government of Assam. The father of the petitioner, Ravindra Kumar Gogoi, who was a grade 4 employee in the Borahibari MV school, died in harness on 10/11/2008, and on his death, the petitioner submitted an application for compassionate appointment on when did you submit your application? The said application was considered by the DLC of Shivsagar district in its meeting of 13/3/2013, and the claim of the petitioner stood rejected by providing that no vacancies were available for any such recommendation. In the circumstance, this writ petition is instituted by the petitioner claiming a legal right under clause 15 of the OM dated 1/6/2015, which provides that in the event of there being no vacancy in the department concerned, it would be open for the concerned department to move other departments to explore the possibility of there being any vacancy available. In view of the above, this petition stands disposed of, requiring the petitioner to approach the administrative department, that is the Elementary Education Department, and the department, upon being approached, may explore the possibility with other departments regarding the existence of vacancy, and if there is any such, and if any such vacancy do exist, and if there is any such communication from the other departments regarding the existence of any vacancy, the application of petitioner may again be placed before the DLC for its consideration. Yes, Mr. Mojumdar. I don't know the purpose of big oil and for the health department. For the health department. Please. You're always welcome.
30 September.
You file, will accept it.
Item 5.
This item 5. Where is the DLC? Page number 39, DLC. Where is the recommendation? The name is Pulokes Gogoi. Pulokes Gogoi. Assistant. Where is the recommendation? No. 13, name of department, office of inspector, vacancy position 15. Name of post, this, assistant teacher, name of candidate. Only the name of candidate, but where is the recommendation that you are recommended? It's there in page 40, not 39. And where is the assistant? Yes, Mr. Pegu, what do you say? Is covered by the Supreme Court judgment. It's covered by one Supreme Court judgment, I think. Khadim. Khadim. Let's check up the name. I think it's Khadim. Khadim. What do you do? Take note of Khadim Hussain and let the SLC reconsider. Heard Mr. Your name, D. Gogoi, Learned Counsel for the petition. Also heard Mr. G. Pegu, Learned Counsel for the SLC and the Deputy Commissioner. Deputy Commissioner, which district? Dhemaji, as well as Mr. S.M.T. Chisti, Learned Counsel for the Secondary Education Department. Who is the name of the father? He did not even write his name. Synopsis, you write. Synopsis is not a part of your. The father of the petitioner, Mahananda Gogoi, who was serving as a. Why didn't you write your petition in a complete manner? Was an assistant teacher in the Ziadhal High School, Dhemaji, died in harness on 23/8/2002. On his death, his wife, being the mother of the petitioner, submitted an application for compassionate appointment on which date? On 1/11/2002. What happened to that said application? Although the application was accepted by the authorities, the same was not given a due consideration. In the circumstance, the petitioner, who was a minor at the death of his father, upon attaining majority, submitted an application for compassionate appointment on 8/10/2015. The said application was considered by the DLC of Dhemaji district in its meeting of, please wait, of 28/12/2021. Mr. Gogoi, he gets disturbed because stenography is they record only the sound, not the words. So when two sounds are coming, he cannot record anything. That's why we ask not to interfere. They don't record words like you write in English. The way you write, they don't write like that. They only record the sound that they're hearing. And have you ever noticed how they write? The signs are like those musical things you have noticed that it's something like that. So don't disturb this. Yes, Kili, yes. Which was considered by the DLC in its meeting of 2012-2021 upon evaluating the existence of vacancy for assistant teacher. Evaluating that the vacancy, that 3 vacancies were available for assistant teacher, the committee recommended the petitioner as an assistant teacher, and it was also noticed that the petitioner had the qualification of BSc, DLED, as well as TET, which in other words implies that he was duly qualified for being appointed as an assistant teacher. But when the recommendation was placed before the SLC in its meeting dated, what is the date? 1/3/2022, it stood rejected by providing that the petitioner was a minor on the death of his father, and the application was submitted about 13 years, 1 month, 15 days after the date of death of the deceased government employee. When he had attained the age of 30 years, this may go against you because Supreme Court says immediately after attaining majority, I think. Ms. Khadim Hussain. The petitioner accedes the rejection by the SLC by relying on the proposition laid down by the Supreme Court in Syed Khadim Hussain versus State of Bihar and others, reported in 2006 9 SCC 195. In the matter before the Supreme Court in Khadim Hussain, Syed Khadim Hussain Supra, the widow of the deceased employee had made an application for compassionate appointment within the prescribed period, which was rejected without assigning any reason. And when the applicant therein attained the age of majority, he submitted an application for compassionate appointment, which was also rejected. And the Supreme Court was of the view that it was incorrect on the part of the authorities to reject the application, as in the meantime, the applicant must have crossed the age of 18 years. As it is noticed that the proposition laid down by the Supreme Court, it is noticed that the reasoning given by the SLC appears to be inconsistent with the proposition laid down by the Supreme Court. We remand the matter back to the SLC to reconsider the recommendation dated so and so by the DLC in his favor by taking note of the provisions in paragraph 5 of the judgment rendered by the Supreme Court in Syed Khadim Hussain Supra, and accordingly be placed before the next SLC.
Item 6.
Eternal prayer, Mr. Bigo, Legal Department. Take it.
Item 8.
Item 8. Yes, sir. Yes, Mr. Page number. T4 is the recommendation. The name of the petitioner. No, DLC rejected or recommended? Page 15. Where is it? Hmm. Digonto Bora is submitted to the
The proposal of Sri Digonto Jyoti is submitted to the Executive Committee for perusal and necessary action. Therefore, SLC is 24.
just a minute. Where is the recommendation?
Madam, page 14,
No, no. Where is the recommendation? Page 14.
page 14, madam, serial number 28, madam.
Hmm. No, you see, come to 14. DLC after threadbare recommended the below mentioned candidates. They are very clear. Proposal of Rajita Kuli was recommended by the in 2017 documents again forwarded. Proposal of Digonto is submitted to the for perusal. They are not recommended.
Perusal and necessary action.
This is not a recommendation. They have only forwarded it.
Madam, yes, sir.
We send it back to the DLC.
But it was written for the SLC.
Okay, issue notice. Will you approve it? Let me ask a notice 6 weeks extra please 3 days. Next item. We have already.
Item 9.
There is no recommendation by the DLC. DLC only forwards your paper to the SLC. So SLC cannot do anything. So it is the DLC who will have to take it. We wanted to send it back to the DLC. But you are not agreeing with it. So we'll hear you on the next day. Just next item. Okay, please let Mr. Nathan. We'll hear you on the next day.
Item 9.
Because there is no recommendation by DLC. Please take note. No problem. Papers were forwarded. That is not a recommendation. Your submission is not relevant as long as there is no recommendation by DLC. Yes, Mr. Nath, what is the matter? See, originally assistant teacher in some BTC school.
Yes,
So transferred to some other school.
some others.
Ah,
Under the, no, BTC,
ah.
number. Thereafter, the director of elementary education, Assam, and took a notice, by showing all that the appointment was in the other application.
Miss appointment in BTC was genuine.
Yes, was checked.
Then after that.
And then after that was very,
So what to do? We'll issue notice. We'll hear you.
yes, sir.
Yes. Today we cannot do anything. As though as not notice 6 weeks, extra copies 3 days. This after 6 weeks.
Item 10.
Then BTC correct. Yes. Please to protect from being deprived of their rights by appointing fresh. So where is the appointment of the petitioner? Page 21. Page 21.
By the document is required. Then, madam, I will access C,
Page number
page number 33, madam.
33.
The Government of Assam in April 2023 decided to publicize the 419 year episode of the soil regarding the budget. 419.
So was the petitioner included within the 2 posts?
No, we are up for 419 episode.
Understand. Come to page 33, second paragraph.
Yes.
In this connection, 2 posts of teachers for each of the 419 LP school and so shall be created.
Yes.
So now petitioner is appointed in Torazan LP school, which is provincialized. two posts are available, is the petitioner included within the two posts or he is beyond the two posts?
In the communication also, you to consider over 19 number of tea garden managed every schools, two any schools and one high school. As per list of schools managed daily. Whereas Jensen with the condition that the service of the assistant teachers engaged by the tea gardens management will not be commercialized. However, these teachers can continue to serve in the same school under the pay role of the concerned tea gardens.
So now they want to remove the petitioner. Why they want to remove? Which document shows that they want to remove the petitioner?
By this officer, because once were teachers are commercialized, not we, we are serving. Then while after the teachers go with the garden owner, we are different service. I don't know how we are. We could do our
Yes, Mr. Pupan, what is the condition of provincialization is two teachers will be provincialized. Other teachers will not be provincialized, however, they can continue. So, Mr. Sharma's grievance is they can continue, but now you are trying to discontinue. You cannot do that. This is not a regular provincialization where the teachers who are not provincialized, nothing is provided. Here you are specifically provided that two will be provincialized, rest of the teachers can continue, but at the expense of the school concerned. So you, because by virtue of this order, you cannot discontinue them now. The original school is keep on paying them. But Mr. R.P. Sharma learned also.
Can I get my instructions?
So we are passing an interim, you file your affidavit. We are only implementing your own order by the interim. And Mr. R.P. Sharma learned counsel for the petition, also heard Mr. E. Putan learned counsel for the secondary education department, and Mr. S.K. Mehdi for the respondent number 4, notice 6 weeks, extra copies 3 days, steps on respondent number 5. Why have we made them a party? They are under them the earlier school function. Respondent 5. So as well, I rest of those 3 days. The petitioner was appointed by the Torazan Tea Company Private Limited as a school teacher in the Torazan Tea Estate. As a school teacher in the Torazan Tea Estate LP School. School teacher in clerical grade. Again, what do you mean by school teacher in clerical grade? No, school teacher in clerical grade. What does it mean?
No, they have to work in the school, they have to work in the
Okay.
and also sometimes they have to work.
Basically, they're employee of the garden. You will be a school teacher. After the school hours are over, you will go and work in the garden office.
Garden or somebody.
So school teacher at Torazan. You appointed a school teacher in Torazan. The appointment letter provides that the appointment is as a school teacher at Torazan Tea Estate in the clerical grade 3. The petitioner accordingly joined and is continuing with the discharge of his service. The government of Assam through the secretary in the secondary education, school education department issued a notification dated 18/4/2023, which provides that in the public interest and in the academic interest of the tea community, the government of Assam in the Department of School Education is pleased to provincialize 419 number of tea garden managed LP schools. by providing that two posts of teachers for each of the 419 LP schools would be provincialized, and for the purpose, the required post would be created. But the notification also provides that the services of the existing teachers engaged by the tea garden management will not be provincialized, and these teachers can continue to serve in the same school under the payroll of the concerned tea garden. Full stop. In the circumstance, this writ petition is instituted on the apprehension that because of the order of provincialization for two teachers of the school, the authorities may discontinue the service of the petitioner. As regards the apprehension for discontinuation of the service of the petitioner, it is noticed that the notification itself is explicit enough that the services of the existing teachers engaged by the tea garden management will not be provincialized, but however, they can continue to serve in the same school under the payroll of the concerned tea garden as on date. Accordingly, it prima facie appears that even if the service of the petitioner is not provincialized, if he does not come within the two posts earmarked for provincialization, his service would continue as it existed earlier. The notification dated, the provincialization by the notification dated 18/4/2023. It is in the interim, it is provided accordingly. One petition. That's what. 3 petitioners, 3 school, and 1 petition. That is not maintained. Mr. Under a cause of action. Should have filed 3 separate petitions. What do you want to do? Sorry. Court fee, we are not interested, but for our order purpose, then you give the secretary the particulars of the other 2 petitioners, how they were appointed. Okay, do first paragraph of the secretary. Yes, next item.
Item 13.
Yes, and then Bolgi. What is this? Certiorari causing the impugn DLC 1510. Which page? 90. Underqualified. Yes. Sorry. I think Santosh Assembly. NC. Okay, the norms prevailing on the date of consideration. But Mr. Anand, we are a concerned petition also have Mr. P. Saikia for the correspondence number 1 and 4 being the SLC and DLC of which district? Of Hailakandi district, as well as Sharif Kupan for the Elementary Education Department, Government of Assam. The father of the petitioner, Sanjay Kumar Nath, who was an assistant teacher in the 588 number Pavanandapur LP school, died in harness on 16/6/2013, and on his death, the petitioner submitted an application for compassionate appointment on 1/1/2014. By the order dated 11/10/2021, the petitioner had been informed that his application was considered by the DLC in its meeting of 15/10/2021, but rejected on the ground that on the date of submission of the application, the petitioner was underqualified in as much as he had passed the higher secondary education examination in the year 2016. Full stop. The proposition had been settled by the Supreme Court in paragraph 35 in its judgment rendered in NC Santosh versus Winslow, reported in Winslow, wherein it is provided that the norms prevailing on the date of consideration of the application shall prevail and not the norms that may have been in existence when the application was made. In view of such proposition, later on Supreme Court matter remanded to the DLC of Hailakandi district for a fresh consideration of the appeal and to be placed before the next available DLC.
14,
D. Das. Yes, Mr. Das. Assistant Laboratory, Dibrugarh University. So what happened? So you want to say that directing the cancel the entire selection, right?
No, there is no provision for voting because assistant library now it is mentioned in the advertisement also. Two have been advertised in the advertisement. One is for librarian and another is assistant library. I am highly qualified candidate. I have NEET pass.
No, that is okay. Now,
Now, one who says it on the basis of interview. The library has been free
where is the interview?
in
Where is the advertisement?
advertisement.
Who appears for Dibrugarh University? Do they have any standing counsel? Advertisement case number.
Advertisement in page 47.
47.
Annexure 8. Application. Going to be mentioned about one, two, that is
And where is the appointment of the librarian? You say librarian was appointed without written test. Where is it?
this morning I got the confirmation about it because the librarian has already been that is appointed in the month of March.
As per the same advertisement.
Same method.
But Mr. T. Das and counsel for a petition. I যদি নামটা করাই দিব
I guess also section 20.
on the hearing they will hear it. Okay. The petitioner is a petitioner offered her candidature to the post of assistant librarian pursuant to the advertisement number A3/2022 dated 7/10/2022 of the registrar in charge of the Dibrugarh University, which is annexed as Annexure 8, page 47 to the writ petition. The advertisement was for one post of librarian, where the required minimum qualifications are provided, as well as for one post of assistant librarian, where also minimum qualifications are provided. The petitioner, upon participating in the selection process, the petitioner noticed that for the post of librarian, the procedure followed for selection is different from the procedure followed for the assistant librarian, to the extent that in respect of the librarian, it was done on the basis of interview and other credentials of the candidates, whereas for the assistant librarian, a written test was also held. The petitioner makes out a case of violation of Article 14 to the extent that two different procedures had been followed for the purpose of selection of two posts, where apparently there does not exist any intelligible differential. Full stop. It is stated that the librarian had in the meantime already been appointed, and the process for selection of the assistant librarian is presently on. In view of the aforesaid submission that 2 different procedures had been appointed for 2 posts under the same advertisement, further selection process for the post of assistant librarian shall not be carried forward until further orders. List on so and so notice. 4 weeks. 4 weeks. List on so and so. Jodi ahe, mojon dibo, jodi nahe. Unrepresented, steps were established. If he does not come, if he comes for this name.
Please stay vacating.
Yes. Stay vacating. You're for the writ petitioner or you're for the applicant? Which order, interim order is to be vacated? Page number?
111,
Page number.
Is there item of case number 90? 196.
We'll have to hear this matter. We cannot go for only vacating state. Who are you? Who is the applicant? No, president is the writ petitioner.
He is already functioning.
So, how the headmaster is aggrieved? What legal, just a minute, what legal right the headmaster has as to who will be the president of the school managing committee? What is your legal right? And number one, the applicant is the headmaster. Applicant seeking for vacating the interim order is the headmaster of the school concerned. The applicant to submit before the court as to what legal right a headmaster has as to who would be the president of the school managing committee and in what manner the headmaster is prejudiced by the interim order. List on so and so. Next item.
16 prohibition.
You are headmaster, you function, no one is disturbing you. Yes, Mr. Chisti. Mr. Chisti. Mr. Chisti. Mr. Chisti. School managing committee, what role the headmaster has on the SMC? Nothing. So whether the president is suspended, he is getting an interim order, how the headmaster is affected. Now a headmaster has come to vacate the interim order. So please look into this matter. We want to understand the locus standi and legal right of a headmaster as regards who should be the president. You come prepared. Mr. Mozumdar, if you want, we can record your name. Yes, next item.
Item 16 prohibition.
Admission. Mr. Mozumdar, we have passed an interim order, you respond to it. One advertisement, one librarian, one assistant librarian. Librarian appointed by following a different procedure, only interview. Assistant librarian, he is agreed, written test and everything, different procedure. Almost same post without individual difference here. One advertisement, by 2 procedures. We state for this. Yes, Mr. Choudhury. Seek for direction by appointment. 2008 compassionate appointment. How is it still surviving? Maybe, but what was he doing for almost 15 years now? Understand? Who appears for the home department? You appear. Okay. As a photocopy of the letter containing signature is available, we wanted to place it before the forensic authority to compare it with any known admitted signature of Apurva Das. Do you have the report of the forensic? The respondents in the home department to make available the report of the forensic department as indicated in the order dated 31/2023. Responses.
Item 17.
It's item 17. Records are not available. It is stated by MS R. Dekhal and counsel appearing in the for the excise department that the records as required is yet to be made available. Adjourn for 2 weeks for the records.
Item 18.
Some date will be given.
Already prepared start hearing.
Before some other court.
Honorable, Your Honor.
Before this court.
Petitioner has some days before that and his legal here there's some schedule.
So that 10-year-old girl who became pregnant. Who appears for the respondents? Government, Social Welfare Department, and Mr. I think Mr. Nathwal appearing. He's having some inconvenience. We post it next week. Next week, I will. Adjourned on the inconvenience of Mr. G. Nath and Serikata to be listed now.
12/9.
Is she getting some money now?
Still isolated.
Paid. Now, what further is to be done regarding the trial of the accused?
Trial, I hear that the trial already completed.
Trial is also now. What further remains in the petition?
Some government will provide some compensation.
No, 3 lakhs is already paid. I think we asked the government to take care of the child, I think. Because, and the father had already died in the meantime.
Yes, sir.
Father is dead.
Like, it is road accident.
When?
You can say.
Acha, after the last order. But Mr. Nathka will try to provide some government aid for this child for education and all.
Item 19,
Yes, Madam Devi.
This is not the installation of the Salesforce employee who was working as a job gate tool. But Hyper committee was rejected on the ground that he was doing the second post. But the person who is already been regularized, they were working as a gate, second gate. In spite of that, they have rejected my pay.
No. Before we go first and second, is there any provision that only one drop teacher will be there? If 2% are dropped, what will happen?
Actually, what happened
No.
at the time of the installation, first one was.
No, please listen to our question. If there is one drop person, we understand. They'll consider. If there are 2 drop persons, what will happen?
They have approved.
No, they'll have to give both or only one.
No, but at the time of commiseration, they will get only one. Because there is a provision for only one.
Miss Madam Devi, you uttered the word drop.
Drop it for,
Drop means not provincialized.
not the-
We are asking you, drop people are also being asked to be given the benefit of provincialization. How many? Is it limited to one, or if there are 2 drop persons in one school, both will be provincialized?
Sometimes when I have seen that.
Yes, Mr. Sharma, any
My
idea?
December full court has already been passed an order. May I please report the process? Take it one day.
Yes, Mr. Sharma, what is it? Mr. Sharma, therefore they have come before the court. Now, what is your submission on their claim? For drop teacher, there is no sanction post. It's only a requirement of law to be provincialized. Adjourned on the prayer of Mr. U. Sharma, line counsel for the Education Department, to examine the claim of the petitioner that although he is the second drop grade 4 employee
Yes.
in the school concerned, his services had his claim for provincialization had been rejected by the high power committee. The question for decision that may arise would be whether, for the purpose of regularizing the drop personnel from provincialization, whether it would be limited to only 1%, or if 2 drop persons are available, both can be regularized. Respondents to answer the question on the next returnable date, response. This Kudus is different.
15th September.
Kudus only one man. Kudus only one person was there.
No, actually, what happened in this case, all the second drop get code across this honorable court, and this honorable court passes.
They didn't give us that order, not this order.
Yes, sir.
Yes, next item.
Item 20,
25(3). the respondents to provide the information as indicated in the order dated 25/3/2022 list conference. I think there is a dispute of fact. You claim that it is not there. He says that something is there.
21,
21. None appears matter is possible for that day. You want to file affidavit? Your name, please. For which respondent? Mr. N. J. Chaudhary for respondent 4, please for 2 weeks time to file an affidavit incorporating certain important documents. Certain documents which the petition respondent feels are important documents. You want to file? Mr. U. Sharma makes a similar prayer for filing affidavit on behalf of the state authority. Yes, next item.
item 22,
22. 22 you are repeating, Mr. Chetri. What is to be done? Any affidavit file? No? You want to file affidavit?
Similar cases, there was an order to complete the selection process that we have completed. We have to file a review petition in those cases because there was a specific company from the external where approach with answers which to be.
So you file your affidavit. Mr. R. Modulkar,
Sorry. Only this particular earlier occasion also he is repeated the same thing. Now.
so let you file affidavit, you give your reply. Understand. Within 2 weeks you file to seek an adjournment to file the affidavit in opposition. Mr. B. Chetri objects to the same, saying that the matter is pending since 2021 and no effort has been made to file the affidavit. Affidavit to be positively filed before the next returnable dates. Response.
18 September. Item 23.
23 who is appearing. MH Losko. Yes, Mr. Losko. Sorry. Today he is not. It's stated that the Rand Senior Council, Mr. H.R.A. Chaudhary is having some inconvenience today. Adjourn list on switch.
item 25,
Take a date. 25. A.Y. Chaudhary. And none appears for the petitioner adjourned. Next time.
26,
You are only respondent. You are having urgency. Some stay order is there. None appears for the petitioner. Mr. A.K. Hussain, and comes the respondent number 7, states that the respondent is having urgency in the matter in as much as because of the pendency of the writ petition, who is not doing. The school managing committee is not doing the needful by citing that the matter is sub judice. We clarified that there is no interim order and there is no restraint order on the part of the SMC to carry forward the requirement. Next item. Withdrawn again. Next again. Yes, next item. Deputy Commissioner. Deputy Commissioner.
item 26,
Give the correct facts only, then our order will be right. So we are clarifying that there is prejudice cannot be a reason. We take this order, go to the Deputy Commissioner. Yes, Mr. Where is the DLC? 53. Serial number Debobroti Day, assistant teacher. DLC discussed. Is it recommended or what? Where is the word recommended?
Page 5611.
56.
11.
There, and then 56. Then why SLC rejected? Page number? Page number?
It is from 58, 61. 61.
Devot. Devorati. What is this norm of 16/2016? We've already clarified it is directory.
But the thing is that here in this case, otherwise that part is understood. This one followed by on 11/7/2016. Then applied on after 6 years.
After
6 years. That instruction is there.
mother did not apply.
Otherwise,
Yet file your affidavit. Initially, mother applied, but actually, according to mother, also did not apply. So, how can you check out whether mother had actually applied or not? Page 46. Zobadev is the mother. Where is the original you are having? Let us see. No, this is a photocopy you had made for making it annexure. What document you are having? Let us see. Ask your client to produce the origin of this one. The page number by submitted by her mother, it is there. Discuss the submission of the in the meeting. Prayer petition submitted by mother, it is there, Mr. Pegu. DC also says there is a docket number. Just because your record now does not contain, it doesn't mean that they are not given. Mr. Pegu, G. Pegulan, Adjunct Second Advocate, raises an objection that although the petitioner claims that earlier an application for compassionate appointment was made by her mother, but the present records of the authorities do not reflect any such application, and therefore it is to be understood that no such application was made by the mother. But Mr. Anne Hogland comes up with the petitioner firstly points out to page 56 of the writ petition, which itself is a copy of the application of the mother, Srimati Jobadev, wherein there is a docket number receiving the application, and further the DLC in paragraph 11 of its resolution dated 2/2/2022 had also provided that the DLC had discussed the prayer petition submitted by the mother of the petitioner. Full stop. Mr. Pegu seeks for adjournment to further examine the matter. Responses.
Item 27.
Provincialization. Have you filed affidavit? You want to file affidavit? Respondents. Who is appearing? You are. You want to file affidavit? Do you intend to file affidavit or you do not intend? You don't have to. what is the department? BTC, MSP Das opinion from the BTC states that the respondents in the BTC are not required to file affidavit in the writ petition for the education department. And MSN Fukan for the elementary education department, on the other hand, prays for 2 weeks time to file the affidavit, prayer of just after 2 weeks.
28,
28. Page number. Page number. Who appears for the government? Mr. Pegu. Yesterday, we allowed one petition based on the judgment of the single judge, setting aside the provision of balance 3 years. Here, Mr. Bokolial, as State Council, took the plea that against that judgment, one appeal has been filed. So here two contradictory stands. Yesterday, no one objected. Today, we notice appeal filed. What is your stand? What happened to the appeal?
Now only notification for regarding delay. And I have already open order. What you can do?
That is,
Step down. Step down and allow to submit before the decision. Dispose of equity land.
so yesterday we passed the same order, we say, Khali is the same question. Same order तुम्हारी 3 years to start down. Same copy तुम्हारी facts लगी वो नहीं. Give the facts of the petitioner. We passed the same order. I think it was day before yesterday we passed.
29,
Yes, 29, Mr. Chakraborty. 1 to 5. Mr. U. Sharma for a secondary praise for 4 weeks time to file affidavit prayer on this topic. Is it till today? Interim order to continue.
24 orders,
I don't know the prayer of Mr. A. Narjari, who had submitted that the pleadings are over and the matter can be given a hearing. Just again.
31,
I don't know the prayer of Mr. SMT Chisti for the education. But no one has appeared. Why are you taking that? Mr. Chisti, no one is there for the petition. Which is state.
32,
32. Contempt. So has the notice been served? Notice 20. A David service report on the respondent number
33,
33, yes. But they did not, you continue. But they have not made a mention. Then what to do? On your behalf. on their behalf. What's your name? Mr. A. Ahmed, Learning Council stated that the respondents had informed the Learning Council that an adjournment would be sought for. But unfortunately, the respondents have neither made such prayer before the court nor they are present when the matter is called adjourned.
34 and 35.
Here also they have the complaint order, but last session the case was said it will not apply. So,
Mr. Borbuya, your very first statement goes against you, not properly compliant. If it is not proper, there is nothing in the law in a contempt that it has to be properly compliant. And in fact, there is nothing called compliance. It is willful and deliberate violation. So even if it is even remotely complied also, it is no longer a willful and deliberate violation. You file a writ petition if it is not properly. Find where is the direction? Let us- Page number 34. It will revert to submit a representation individually along with this order. Mr. Bormia, why do you accept this kind of a order from the court? The day you accept, you're very happy, my purpose is fulfilled. But this kind of a order will not help you in any manner. Always take an adjudication. Yes, you are entitled or you are not entitled. This order is nowhere. All that it says that the government may examine the claim of approval on the basis of relevant document and rules. They quote a writ appeal and say you are not entitled. End of the matter. So therefore, Mr. Borbuya, if it is a minority school, is it subjected to writ jurisdiction? Will a writ petition be maintained? Mr. Borbuya, will a writ petition be maintainable against a minority school? Service condition in a minority school?
And other terms and conditions that follow. In this case, also particularly this school challenge the virus of the Rule 5 and 4 of the 1977. This initially this was going to dismiss the writ petition of the school is challenge. They are going to the Supreme Court. Allow their writ petition.
Saying
They have
what?
given the power, and the committee has the power to appoint the person. They have to administer, they have to study.
So, moment managing committee has the power, your minority status goes. It is not a,
That is,
it is not an absolute minority institute. Now it is a conditional minority institute.
That also taken care of by the honorable.
So, but you have to challenge this order. I heard Mr. F.U. Bormia, Learning Counsel for the petitioner, also had Mr. S.M.T. Chisti, Learning Counsel for respondent contemners. This writ petition is instituted alleging willful and deliberate violation of the order dated 22/3/2021 in, amongst others, WPC 3484/2023. 2013. The relevant provisions of the order is extracted as below, para 12 and para 13 below. A reading of the order makes it discernible that the legal right of the petitioner to be what, regularly appointed, Mr. Chisti. What is their claim in the writ petition? What do they want? Approval of the
Reading of the order makes discernible that the legal right of the
petitioner claiming approval of appointment in the school on the basis of relevant documents and rules had not been finally adjudicated. But what had been directed was that the respondents would consider the documents and relevant rules in the individual representations of the petitioners and accordingly pass appropriate order. And if the appropriate order would lead to an approval by the authorities, necessary action for release of salary be taken. Pursuant to it, Mr. SMT Chisti Land Council has produced the order dated 18/5/2023 of the Director Secretary Education Assam, by which, placing reliance upon a division bench judgment dated 17/6/2023 in WA 252/2023 2003 17/6/2003 in WA 2003. The claim of the petitioner for approval of appointment stood rejected, as the order was of the court was only to give a consideration to the representation and pass a reasoned order. We are of the view that no further willful and deliberate violation can be alleged and sustained in this contempt petition. Contempt petition closed. However, petitioners given the liberty to assail the order dated 18/5/2023 if advised under the law. Sorry. This is item number 34. 35. Yeah, yes. Will the same order do, or repetition will be different? Repetition will be better. It will second to hit money. Communication part of the report. Mr. Bormia, in a content we cannot decide it anymore. You find repetition, we'll definitely hear you. And never take this kind of orders from the court. It doesn't help you in any way. Always get the matter adjudicated, either yes or no. Who appears, the respondent? You want some time? Adjourn on the prayer of Mr. K. Gogoi, Land Counsel for the respondent containers in the Higher Education Department, for obtaining certain clarification as sought for. List counsels.
38.
38. F.U. Borgoya, same your matter. Issue notice. Await service report as per the office note dated 29/8/2023.
39.
So it has, who appears for the respondents? Notice issue. Awaits service report on respondents number 1, 2, 4, 5, 6, 8, and 9.
40.
Await service report on respondents number 9 to 13 with reference to the office note of 29/3/2023.
41,
Yes, 41. Has it been served? Service complete? You please check up. So petitioner to check up from the office note as to whether service is complete. Next item. Interim till today. Is the interim till today? Next item. Yes.
I think 42
Check up
for
first.
admission.
You read the file and then submit. First, check up whether notice is served or not. Secondly, check up whether interim is until further orders or until today. Yes, Mr. Nemish. No. Mm. No, true. No, has notice been issued? No, the petitioner serving an assistant teacher. One is a senior most after retirement of development team. So your grievance is against respondent number 6.
Respondent number 6 was appointed as insert principal. That matter has been suspended by your worship.
Okay, now.
By order dated 1/11/2020. Now, whatever I have been given academic insertion, but insert principal post is not given to me from 31/3/2023.
In other words, you are requiring him to do the duty, but not allowing him to deal with the money of the school.
Financial punishment.
Give it. If you give the whole thing, why are you holding back something? See, when the court had stayed the in charge of respondent number 6, and you were giving it to him, give him in a wholesome way. Why only give something and hold back something? List on 7 for further consideration on the allegation made by Mr. M.S. Sheikh when comes the petitioner that after the interim order of stay against the respondent number 6, the writ petitioner had been made the in charge headmaster of the school, but is given only the academic charge and not other charges. Mr. Bojumdar to respond to the next day. Why only a limited entitlement is given and not the complete entitlement? On 7. It's a principle. Mr. Sheikh, it will not be 7 some other day. I think 7 there are too many matters. Some other day.
43 for orders.
Yes, IA for what purpose? Yes. IA used to stay the impugned letter issued by the. Where is the impugned letter? Page number. To Abdul Rahman. You are Abdul Rahman, petitioner. No, petitioner is not Abdul Rahman. What is this, Mr. Bojumdar? No. What is the dispute and what is this letter? Who is the applicant? Who is the petitioner? Sahidul Islam Mullah is the writ petitioner. Sorry.
They are the public.
Just a minute, writ petitioner is the public. What do they want?
They want that this is too much.
Uh,
Should be amalgamated. Should be local levels.
This school should be, just a minute. Porbandar is mentioned for the provision to receive report forbid from. So public has come against Mr. Sheikh. If you give my reply to my question, it will be even more simplified. Public has come opposing the merger of the school. And there we have issued notice. Now, what is, and you are for the public.
Yes.
You are for the public, you want that merger should take place.
That matter is illegal.
Achha, you are opposing the merger,
Yes.
public.
Yes.
Okay. And now what is this annexure 7, page 7 annexure?
Annexure 7 is. Now, the headmaster of the basic school directed the inside headmaster of our school that you deposited the furnitures, etc. to the basic school.
And where is the order of merger?
Well, order of merger, your lordship will get in the report.
Page number,
That page,
page 13, I think. But there is no stay order. There is no stay order. So if there is no stay order, they will, he is rightly issued
as
that.
for the furniture, that is all right. But our submission will be present this case matter. That if everything is taken away during the subsistence, then during when the matter. is
No,
submitted,
but then you should pay for an interim order.
but that interim order is not allowed in there.
It is not allowed.
That is why. That is
So,
why-
Mr. M.H., you filed an IA for interim order. If we allow it, everything will be staged. If you don't allow, you cannot stop them from going ahead.
At this stage, for us, since the evaluation is already taken place, students are already based.
Mhm.
We need the based cater to the students' interest. So at this stage, staying that part.
That's what we are saying.
The amalgamation is for a concept of giving the students a better benefit. It's not the benefit of the GB or the teachers concerned.
No.
Students will
List the IA along with the repetition so and so, final consideration would be given. Respondents to file affidavit in the meantime.
In the meantime, regarding stay matter, we have filed a petition for stay also.
It is not here.
Kabul to 9.
Babu, okay, it is there.
That is on record.
All the 3 applications will be heard on the next day. When do you want? Take an early date.
Yes,
15 will hear the matter.
59.
If you interfere with the merger, it will be there. If you don't interfere, it has to go. Miss, in between halfway, doesn't gain, no gain for anybody.
Exactly, my lord, if it is amalgamation is interfered by your lordship,
Everything will go. Let us see whether what right you have, why should you interfere, we'll hear you. Yes, next item. 44. I know. You appear for number 7. Your name. Amar Chaudhary appears for response 7. Prays for how much time? 2 weeks time to file affidavit. This after 2 weeks.
25.
Not yet. We have to find out the new address, left without address. The office note of 31/8/2023 provides that the notice on respondent number 3 could not be served as the notice had been received back and served with a postal remark left without address. The petitioner to verify and provide the correct present address of the respondent number 3. And thereafter take steps on the correct address by registered post.